This is part 7 of the series about the various stages of life and the financial considerations that come with each one. In part 1, we spoke about getting your first job, then we looked at marriage. In part 3, we discussed the impact of buying a house, followed by having a baby, and the cost of education. And last week, we explored retirement. This series is also available in video format if you prefer that over podcasts. The videos cover each topic in more detail, and I will provide the links at the end of this episode. Today, we are ending the series with a discussion around death and related costs and administration. Death is an inevitable part of life, and it's important to plan for the financial implications. This means having a solid estate plan, including a will and power of attorney to ensure your wishes are carried out. It's also important to consider the costs associated with death, such as funeral expenses and estate administration fees. Planning ahead can help alleviate the financial burden on your loved ones during a difficult time. The administration of a deceased estate in South Africa can be complex and a lengthy process. The following are the general steps that need to be taken. Step 1 is to report the death. The first step is to report the death to the Master of the High Court. This can be done by the executor, the family member, or the person who has knowledge of the death. Step 2, to appoint an executor. The executor is the person who is responsible for administering the estate. If the deceased has a will, the executor will be nominated in the will. If there is no will, the Master of the High Court will appoint an executor. Step 3, gathering information. The executor needs to gather all relevant information about the deceased, including details of assets and liabilities, bank accounts, investments, insurance policies, and debts. Step 4, value the estate. The executor must determine the value of the estate by taking into account all assets and liabilities. Step 5, advertise the estate. The executor must then advertise the estate in the Government Gazette and in a local newspaper to notify any potential creditors and heirs. Step 6, notify the creditors. The executor must notify all creditors of the estate and allow them a period of time to lodge their claims. Step 7, pay debts. The executor must pay all outstanding debts of the estate. Step 8, distribute the estate. After all debts have been paid, the executor must distribute the estate according to the instructions in the will or in terms of the Interstate Succession Act. Step 9, finalize the estate. The executor must prepare a final liquidation and distribution account, which must be submitted to the Master of the High Court for approval. Step 10, obtain clearance. Once the final liquidation and distribution account has been approved, the executor must obtain a clearance certificate from the Master of the High Court. Step 11, transfer assets. The executor must transfer all assets to the heirs or beneficiaries and close the estate. Please note that the above is a general outline of the process, and there may be additional steps or requirements depending on the specific circumstances of the estate. It's recommended that professional legal advice be obtained to ensure that the process is completed correctly and efficiently. The process of winding up a deceased estate can be a lengthy one and may take anywhere from 6 months to a few years to complete, depending on the complexity of the estate. It's important to note that the estate may require a significant amount of liquidity in order to settle debts and distribute assets to heirs. This underscores the importance of careful estate planning and provision for cash flow during this time to ensure that heirs have access to the necessary funds to cover expenses. In addition, it's worth noting that funerals can be expensive, with average costs in South Africa ranging from 10,000 to 20,000 or more, making it all the more important to plan ahead and ensure that adequate provisions are made for final expenses. Ensure your spouse understands what to do when you die. It's important to have open communication with your spouse or partner about your estate plan and what their role will be in the event of your death. They should be familiar with the contents of your will, where important documents are kept, and who to contact in the event of your passing. Have a file with important documents. Keep all important documents such as your will, life insurance policies, and bank account information in a secure location that can easily be accessed by your executor or family members. Choose an appropriate executor. Your executor is responsible for carrying out your wishes as stated in your will. While your spouse may seem like a logical choice, they may not always be in the best emotional state to make important decisions or sign legal documents. Consider appointing a trusted family member, friend, or professional executor rather. Consider taxes and other costs. Estate planning should take into account potential tax implications and costs associated with administering the estate, including legal fees and executive fees. Review and update your estate plan regularly. Your estate plan should be reviewed and updated regularly to ensure it's still in line with your wishes and takes into account any changes in your financial situation or family circumstances or the law. By taking the time to carefully consider and plan your estate, you can help ensure that your wishes are carried out and your loved ones are provided for after your passing. This ends the Stages of Life podcast series. But don't miss out on the next series on Point of View, where we will cover the evolution of change. Here are the links to the full Stages of Life podcast and video series.